I'll vote on it. Very well, bring the jury out, please. You may be seated. Well, good morning, ladies and gentlemen of the jury. Thank you again for being here on time. We are now ready to proceed with the next phase of the trial, and this will be where the attorneys will have an opportunity to present their final arguments to you. They will, of course, reference evidence that has been presented during the course of the trial and try to persuade you to their perspective as far as what should be the outcome of this case. The sequence of argument that the law provides is that the state will go first in presenting an argument, then the defendant's counsel will go second, and then the state will have the final and concluding argument. Once that is completed, then I will give you what is called the charge of the court, and as I've said before, those are essentially the rules, the laws that apply in this case that you will apply to the evidence that you've heard in the case as you evaluate the case and try to reach a verdict in regard to the issues you have to consider. And we'll go into some detail about that at that point, but that's the sequence. Once you have the charge, then you will begin your deliberations, of course, in private in the jury room, and that's sort of the sequence you can expect as we go forward here today. All right, let's go forward with the state's opening.
Thank you. Good morning. I participated in our legal system for over 30 years, and I believe in it, but I don't believe the way we conduct closing arguments is the best way to do it. I think in a perfect world, we could have a dialogue, because I know you have questions. It would be better, I think, to have a panel discussion, whereas I would present my case and you would ask questions, and the judge would serve as a referee, determining whether the questions are relevant or not. But unfortunately, that's not the way things work. And so we do the things the way we've always done them. And so this is my opportunity to argue to you what I think the evidence will show, and I'm going to try to anticipate some of the questions that you might have so I can try to answer those questions. But of course, it's less than ideal. To begin with, it's going to be a little bit dry. I'm going to have to talk about a little bit about the laws. I'm not going to read all the laws to you because that would be excessive and unnecessary, and His Honor will read the law to you at the conclusion of this. But there are some charges that I think are particularly important in this case. I don't know if we have any chess players on the jury, anyone who's played chess before, but in a game of chess, the pieces have values at the beginning of the game. But depending on where the pieces are on the board, the values change. For instance, a queen is typically one of the most valuable pieces, but a pawn that's about to be promoted to a king and can't be stopped, of course, is more powerful still. Like that, jury charges have values that change. In some cases, some charges are more important than others, and in this case, there are charges that I think are more relevant than others. And so what I'd like to do is focus my first argument on those charges that I think are the most relevant to you. And so I'll begin. The first is the judge will tell you that it's his duty and responsibility to determine the law, and he'll give that to you. But it's your responsibility to determine the facts of the case, and nobody else does that. The judge doesn't determine what the facts are. The attorneys don't determine what the facts are. That's solely up to you. And so that's the first thing you need to know. You've probably heard about the presumption of innocence many times on television. So what does that mean? It means just this. The defendant is presumed to be innocent until proven guilty. and that presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. So what is each element, this material that must be proven? Well, everything that the state must prove in its case is contained within the four corners of this document and nothing else. And so you look at the counts, and we'll talk about the charges later, but the state must prove the elements of felony murder, including the date and venue, the elements of involuntary manslaughter, including the date and venue, the elements of aggravated assault, including the date and venue, and the elements of reckless conduct, including the date and venue, and that's it. In a minute, I'll argue and let you know what those elements are, but that's our burden in the case that we have to meet. Now, keep in mind that the state we do have the burden of proof, but we're not required to prove the case beyond all doubt or to a mathematical certainty, so not 100% certainty. And the judge will tell you that a reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is based on common sense and reason. It is not vague or arbitrary. So all that means is, as jurors, you put your minds together, you use your common sense about the way the world works, and you determine whether there's a reasonable doubt in this case. This, I think, is probably, we're getting into the areas in this case that is the most important. We're going to talk about credibility of witnesses, and that means the believability of a witness. And we're going to talk about expert witnesses, and we've had 4. So, I don't know if you know this or not, but the judge will tell you that you get to determine the credibility of the witnesses, you and you alone. So that means that you don't have to give equal weight to each witness. You can accept a witness, and you can reject a witness. You can say, I don't think this witness is worthy of my belief because they're biased. And what do I mean by bias? Well, the judge will say, consider their lack of interest in the outcome of the case or whether they have an interest in the outcome of the case. With that in mind, what is a conflict of interest? And I had to write this down specifically to get this right. I'm going to argue that this case has many conflicts of interest. For instance, and I wrote this down so I could get it right, an individual serving as a board member of Axon who testifies as an expert witness that an Axon product, the Taser, is non-deadly, has a significant financial and professional conflict of interest. That's just simply a fact. The relationship creates an appearance of bias because the expert's testimony directly aligns with the commercial and legal interest of the company they help govern. This inherent bias undermines the expert's credibility and even the integrity of the judicial process. And I'm referring specifically to Dr. Kroll, a former member of 2 Axon boards, who was a compensated board member, receiving for a while $120,000 and $200,000 a year, and who still owns significant Axon stock. In his own words, several $1 million, and he's cashed in several million over the years. So bear that in mind. He's not a fair and impartial juror. He has a conflict of interest. This relates also to Dr. Graham, who is a current member of a scientific board and a compensated member. He also has a conflict of interest that you need to consider. He is biased, not fair and impartial. Ladies and gentlemen, the entire defense is a house of cards built on 4 names. That's Kroll, Ross, Bilkey, and Graham. I told you at the beginning, I asked many of you during the jury selection if you were susceptible to following influences, or you could be influenced, or you would substitute your opinion for the opinion of experts, and there's a reason for that. They're asking you to disregard what you've seen on the video and substitute your own common sense and opinion for the opinion of experts. And this is how it started out with each witness. They provided you a phone book thick curriculum to establish their credentials, and by the end of the testimony, they were simply reviewing the video that you've already seen and telling you what you've seen, right? No true expertise. No true expertise. They're just asking you to substitute your judgment for their judgment. And that's the foundation of their entire case. They don't trust you to make the right call. They don't trust you to use your common sense and knowledge of the way the world works and determine what happened on the street. They're asking you to accept Dr. Kroll's version, or Dr. Ross's version, or Dr. Vilke's version, or Dr. Graham's version. And there's a word for this that we use, ladies and gentlemen. That word is gaslighting. I've written that down. Gaslighting is a form of psychological manipulation in which someone causes another person to question their own reality, memory, perception, or even sanity. Gaslighting includes denying events that actually happened, trivializing the victim's feelings, shifting blame, or rewriting history or presenting false information to create doubt. You've heard me during the course of the trial make several objections, saying that something is argumentative. And you probably heard me repeat it, objection, argumentative. What does that mean? It means that instead of asking a question, the attorney's making an argument. So it's my time to be argumentative, closing arguments. And this is the question I wanted to ask to Dr. Kroll. Are you gaslighting this jury? Dr. Ross, are you gaslighting this jury? Dr. Vilke, are you gaslighting this jury? And Dr. Graham, are you gaslighting this jury? And this is why I'm asking that question. Again, Dr. Kroll has a serious conflict of interest. And he testified that tasers are harmless, and he made us watch that whole, like, 7th grade science video that lasted 2 hours that talked about nothing but electric fences and getting six-pack abs. So that was like the buy-in. So after 2 hours of that nonsense, he testifies some quasi-scientific mumbo-jumbo, and then immediately starts talking about the video that he watched, the video that you've seen, to tell you what you've seen on the video. And so we asked him, he says, a taser's never a deadly weapon, which we know is at this point, because we've seen it in action, and we have other evidence. He says, no, it's never a deadly weapon. So we show him State's Exhibit 32, which I'm sure you're exhausted from seeing. And we simply ask him to read his product's own warnings, right? This is his product. This is Axon. This is their taser. He's an expert. He's paid, $25,000 to come here and be with you. And this is what their own warning says. Can cause death or serious injury. CEWs have risk, and CEWs use physical incapacitation alone in combination with physical exertion, stress, unforeseen circumstances, or individual susceptibilities may risk or cause serious injury or death. This is in their own warning. Then it says, avoid using the CEW, the taser, in a touch-stun except a brief application to attempt pain compliance. A brief application must give a reasonable time and opportunity to comply. So you have to consider if they're complying with the first brief touch. Then it says, avoid repeated touch stuns if compliance is not achieved, especially with these devices. Subjects with increased risk include people with heart disease. Each trigger pull is 5 seconds, must be reasonable. Control and restrain the subject immediately. I mean, if you can put your hands on them, do it immediately. Avoid simultaneous more than one CEW exposure with multiple CEWs on multiple circuits. That means don't have multiple deputies tasing somebody 40 or 50 times like we heard yesterday. My God, that's insane. And I want to touch on that again. Avoid repeated, extended, or continuous exposure beyond 15 seconds absent reasonably perceived immediate threat and justification. For pain compliance, that means if you're using that dry stun, if pain is foreseeably ineffective due to tolerance from drugs, alcohol, or psychosis, stop. Stop using it. And y'all, this is their own literature. And so he comes here and tells you that these things are safe and that death is not foreseeable. Lo and behold, foresee it. It has been foreseen in the document. Is he gaslighting you? Is he gaslighting you? So Dr. Ross comes and testifies. And this guy, he's not a police officer, but he wants to watch the video, which is interesting. Again, he's not a police officer. He has no current street experience. He has not an effective arrest since Ronald Reagan was president. It's the last time he said he participated in any kind of arrest. And yet he's their chosen expert. He's testified 200 times. 200 times always for police officers. Is that unbiased? Is that fair? Is that somebody who's using his training and experience to create a cottage industry? Or is he trying to answer a question? And did he answer any of your questions? Has he influenced you? Did you buy his walkthrough? Was this textbook police work? Would you like to see this repeated over and over again in Washington County? Because I'll tell you this, if it is, there will be dead bodies strewn all over this county. All over this county. Dr. Vilke came from California. He's one of the few that's not a member of Axon, but he has his own baggage. This guy used to travel around the country testifying about excited delirium, which is criticized and banned in many states now. There's a movement toward banning it in all states. And he admitted, yeah, before it was banned in my state, I used to testify in several cases. Well, this is what the American Medical Association says about that. It opposes excited delirium as a medical diagnosis. It opposes it. The policy addresses reports that show a pattern of using that term, excited delirium, as a justification for excessive police force. It has been banned because it's been used specifically as a justification for excessive police force. This is like this excited delirium. Did you hear this nonsense? This is in a way analogous to the drug war that we're fighting. Every time we classify a drug and ban it, some chemist will take it into a laboratory, tweak a few molecules, and throw it back on the streets. That's just what these guys do. They take excited delirium, it's banned, they change the wording in it, and they come right back with a new form of it and try to influence your decision. Are you influenced? Have you been gaslighted? As for Graham, also an Axon board member, biased, has an opinion, compensated board member, purports to be fair and impartial. Is he? No. Nobody who's a board member for Axon can be impartial. He testifies that he essentially accepts Dr. Liebman's opinion, which I'll read to you later. But he wouldn't say it's a homicide. He'd say it's an accident. An accident? An accident is something that happens without your expectation. An accident is not something that is the result of an intentional act. That's just all rubbish, all rubbish. And even he, this is amazing because he was principally a medical examiner, but even he says he watches the videos and try to tell you what he saw in the videos. It's just ridiculous. And this is the foundation of their whole case. It's like this great-looking sandwich, they're correct, of all this beautiful, crusty bread, and then you open it up and there's no meat in it. And you're disappointed. And they built their whole case around this. And they spent over $100,000. $100,000 to target you and try to change your opinion and to influence your opinion and convince you that you didn't see what you saw. Did you? Did you see what you saw? Did you see Yuri Martin helpless, alone on the street, minding his own business? Did you see that police car race up? Did you hear that officer yell, "Tase his ass," when the sergeant was stepping out of the vehicle? Did you see poor Yuri try to cross the street and avoid him? Did you see him chase him down like a dog and tase him and stun him and hurt him? He cried out. He cried out. And he went up the hill. They pursued him like an animal, and they surrounded him. And they didn't use time, and they tased him again, and they killed him. And it's just that simple. And if you see it, the first time you see it, you have a visceral reaction. By that I mean a gut reaction. It makes you sick. It's sickening to watch it. It's sickening to watch it. Do you need someone to tell you how you feel or what you saw? Because that's the cornerstone of the case, ladies and gentlemen. Now, moving away from expert testimony, there's some additional charges I do think will be important in this case. Of course, I told you we must prove the elements. So what are the elements? Well, for felony murder, we have to show that there was a murder, that the defendants caused the death of another person by committing a felony, which in this case is aggravated assault. So 2 elements. They didn't have to intend it. It's not like we think of a typical TV murder homicide. No intent is required. They just intended to do the act, which is assault him with a weapon that was used as a deadly weapon. And here's the causation of felony murder. And I'll read it with another causation charge. You may find the defendant guilty of felony murder if you believe he caused the death of another person by committing the felony of aggravated assault, regardless of whether he intended the death to occur. So, I didn't mean to? No. It's not a defense. It was a mistake. No. It's not a defense. There must be some causal connection. I mean, a connection between the two. The murder is not established simply because the death occurred at the same time. A felony murder must directly cause the death or play a substantial or necessary part of the death, regardless of when the death ultimately occurred. And the judge will read you a second charge that's related to that. And he'll tell you this, and I wish somebody would write this down. Contributing to the death of another. When a defendant unlawfully injures another person, you may find the injury caused the person's death only if the state proved that the injury was itself the cause of the death. 2, directly and significantly contributed to the cause of the death. Or 3, and this is the one I hope somebody will write down, significantly sped up the death, even though the death would have eventually occurred anyway. So even if the death would have occurred anyway, did he significantly speed up the death? And I'll answer that question with Lehman's autopsy report in his testimony. Opinion. The death is classified as having been caused by a cardiac arrhythmia during police restraint. And we know there are other factors they considered because he told you, but this is it in a nutshell. The death is classified as having been caused by a cardiac arrhythmia during police restraint. And if you recall, when Lehman was on the stand under cross-examination, I corrected redirect, and I said, Dr. Lehman, I said, did this assault by the police with the taser accelerate his death? And he said, yes. Yes, it did. In order to consider the aggravated assault, you're also going to have to consider whether a weapon is a deadly weapon. So in deciding whether a taser is a deadly weapon, you may consider the following. The nature and extent of the injury, the character and capabilities of the weapon, the manner in which it was used, any display to the jury, or other circumstances. So, what is a deadly weapon? Is an ice pick a deadly weapon? Well, it is if used to stab someone to death. Is a pillow a deadly weapon? It can be if it's used to smother someone to death. Is a laundry bag, is a dry cleaning bag a deadly weapon? Yes, if used to suffocate someone, it is a deadly weapon. A child's aluminum baseball bat, and the list is exhaustive. Almost any object, if used improperly and in a manner likely to cause death, is a deadly weapon. We don't have to rely strictly on this definition, though, because we have Axon in Exhibit 32. They tell you our product can be a deadly weapon if it's used improperly. So we know that. We have the police training manual, the office policy that says, do not use this weapon under these circumstances on an exhausted person or multiple deputies or multiple tasings because it can cause a heart attack. It says that. All these things are foreseeable. They're foreseeable. They have been foreseen. Involuntary manslaughter, the judge will charge you for involuntary manslaughter. The state must prove that the defendant caused the death of another person without intending to. So again, all the testimony about, I didn't mean to, I'm sorry, I didn't intend to, is out the window. It doesn't require intent by committing the offense of reckless conduct. And this is a reckless conduct. You cause bodily harm to another person because you consciously disregard a substantial and unjustifiable risk that your act would cause the harm to the person. So you know something's reckless potentially, or a reasonable person would. A reasonable person knows this is likely to cause harm. A reasonable person knows that if you chase somebody down and assault them and tase them, that something bad's going to happen, but they do it anyway. But they don't care. That's a reckless act. Pulling a trigger 15 times is a reckless act. Having multiple deputies tase a single individual is a reckless act. Okay? Contributing to the death of another, we've talked about speeding up the death. Parties to the crime, this is important. The judge will charge you that every party to a crime may be charged and convicted with the commission if they directly commit the crime, intentionally help in the commission of the crime, or intentionally advise, encourage, hire, help, procure another to commit the crime. What does this mean? It means it doesn't matter who started this. All that matters is if these defendants intentionally helped in the commission of the crime. Did they participate? Did they participate in the crime jointly together? That's what this is about. The judge is also going to charge you on criminal negligence. He'll tell you that criminal negligence is an act which shows willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured. And that's what we're talking about in terms of that reckless conduct. This is important, ladies and gentlemen. My goodness. Excessive force. A defendant is not justified in using excessive force while acting in self-defense or defense of others. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threat of use of force, then the defendant's actions would not be justified. So, amazingly, going back to the gaslighting argument, they want to argue that perhaps the officers feared for their safety while Yuri Martin was trying to walk away from them, shrugging them off and seeking safety. But even if you believe that they were acting in self-defense, which is insane, was their force excessive? Was their treatment of him excessive? It clearly was. You need to know that you have a right to resist an unlawful arrest. Did you know that? Most people don't know that. If you're not committing a crime, you don't have to comply. And if someone lays hands on you, you have a right to resist. And this is what the judge will tell you. A police officer is authorized in making lawful arrests only the degree of force that is reasonably necessary to accomplish the arrest. So you must only use the amount of force that's reasonable. The mere fact that the lawful arrest is being made doesn't give you the right to use excessive force or an unlawful degree of force. So it's not anything goes, let's up it to level 10 at the get-go. Your force has got to be reasonable. A person being arrested, and listen to this, even if the arrest itself is lawful, so even if the arrest is lawful, has the right to resist the use of excessive force and unlawful force by those making the arrest to the extent that person reasonably believes it's necessary to defend himself. That's a long way of saying if you haven't done anything, you have a right to resist. If you have committed a minor infraction or any other crime, but they're using an unlawful amount of force on you, you're still allowed to resist. Either way, the force has to be reasonable. One upon whom an illegal and unlawful arrest is being made has the right to resist the arrest with such force as reasonably necessary to prevent the arrest. Understand that. If you are being illegally and unlawfully arrested, it is your right to resist the arrest with such force as reasonably and necessary to prevent the arrest. You can use that amount of force that's reasonable under the circumstances to not be arrested. Okay? Yuri chose to be passive. Do you know what passive resistance is? I guess it started off with Gandhi. It was used throughout the civil rights era. It's still used today. It's a way of protesting without fighting, like laying down, not cooperating, or simply walking off. And it's your right. It's every American's right. Those are essentially the charges for now I think are important. Like a chess game, as the defense presents their arguments, there may be a change in the values, and some of the other charges may become more important, and I'll come back and talk to you about it. But that's essentially what we intend to prove. So before I leave, I want to talk briefly about the indictment. We're required to show that for felony murder, there was a felony aggravated assault. We contend that the way that taser was used, it was used as a deadly weapon. It did in fact cause his death. It accelerated that death, so that standard's been met. We have to prove that but for that assault and tasing, he would be alive. We have met that burden through Dr. Lehman's testimony. And we have to prove that it was foreseeable. Ladies and gentlemen, again, I can't beat this to death. My wife says, stop talking about Exhibit 32. They know what it is. They could probably repeat it by heart. That all makes it foreseeable. When they say, I had no idea that could happen, sure they did. Sure they did. It's in the warning of the product itself. I had no idea something like this could happen. It's in your office policy. Know your office policy. They were trained in March. Know your training. Know your training of dealing with mentally ill people. Know these things. Recognize a mentally ill person. The office policy of the Sheriff's Department does not require them to make a diagnosis. They're not required to recognize schizophrenia or any other syndrome. They're simply required to recognize unusual behavior, which was what they stated, whether it be a mentally ill person under the influence of alcohol or under the influence of drugs. They've got to identify those vulnerable people. It's their job. And I'm going to sit down and give them a chance to speak to you, and I'll come back and argue further. But what is the duty of the police department? What is the duty? Is it to go to Cyrus Harris's house, your friend, to make sure he's okay and do his bidding? Is the duty of the police department or the sheriff's department to respond to the first person who calls? So you respond to an incident, you ask the first person who called what happened, and then you take care of business? Or do you have a duty to the community, a wider duty, a responsibility to serve all people? That means slowing things down, asking questions, investigating, finding out what you're doing. It's not about rushing in and busting heads. People with that mentality don't belong in the sheriff's department. These deputies are a stain on this office, and they're a stain on all of law enforcement. And when I come back, I want to talk to you a little bit more about that.
The defendants may proceed.
Trying to get this computer plugged in here. Good morning. I hope you had your coffee because this part's going to be a lot of information. I tend to write this down so that I do not go too long, but stick with me because what we have to talk about now is important. I first want to talk to you for a few minutes about reasonable doubt and the burden of proof, because those are the foundations of everything that you're about to do in that jury room. The judge will give you the law. It doesn't come from us. It doesn't come from the state. If anything I say about the law is different from what the judge tells you, you must follow the judge's instructions. But I do want to highlight what those instructions mean in plain language so you can apply them to the evidence that you've heard. And in that sense, I do disagree with Mr. Lipscomb about one thing. There is no instruction that you will receive that is more valuable than another. Whether it's aggravated assault, walking in the roadway, or the necessity of the state to meet its burden of proof, our laws all matter. Our laws start with a simple rule. These defendants are presumed innocent. The presumption is not a courtesy, it's a rule of law. It stays with them unless and until the state proves every essential element of each charge beyond a reasonable doubt. That's their burden. The burden is entirely on the state. It never shifts. These defendants do not have to prove their innocence. They do not have to prove that the state's witnesses were wrong. They do not have to prove some alternative theory. Under our law, the only question is whether the state has brought you enough evidence to firmly convince you beyond a reasonable doubt of guilt on each essential element of each offense charged. Here, those are aggravated assault with a deadly weapon, felony murder based on aggravated assault with a deadly weapon, reckless conduct, and involuntary manslaughter based on reckless conduct. And I'll walk you through each of these in a moment and walk you through them in context of some of the evidence in this case. What you need to know is if the state fails to carry its burden as to any essential element of a count in the indictment, your duty is to return a verdict of not guilty on that count. Now, what's reasonable doubt? That's what you see behind me. Reasonable doubt is not a far-fetched or imaginary doubt. It's not just any possible doubt, because in any human event, you can always imagine some possibility. A reasonable doubt is an honest, real doubt based on your reason and your common sense. After you've carefully considered all the evidence or the lack of evidence, it's said that reasonable doubt is a doubt for which a reason can be given. Reasonable doubt is the highest standard under the law. It's the kind of doubt that would cause a fair-minded person to hesitate before making an important decision in their own life. Not a trivial choice, but a serious one. If you would stop and say, I'm not sure, I need more before I go forward, this is the kind of doubt the law is talking about. The state does not have to remove every possible doubt, but maybe, probably, it could have happened that way. That's not enough. If after reviewing all the testimony in the exhibits, your mind is left in a condition where you are not firmly convinced, where you cannot say, I am sure of this beyond a reasonable doubt, then the law says you have a reasonable doubt. In that situation, your duty is to resolve that doubt in favor of the defendants and find them not guilty. And consider what counts as evidence. This is important. The judge will tell you that evidence consists of testimony you heard from the witnesses and the exhibits that were admitted. Evidence does not include the lawyer's opening statements. It does not include closing arguments, and it does not include the questions that were asked. What the lawyers say about the evidence is argument. It is not evidence. Your verdict must rest on what came from the witnesses on the stand and the exhibits, not on the theories or the suggestions of counsel. Now apply those rules to this case. The state chose the charges. The state wrote the indictment. The state decided which witnesses to call, which experts to bring or not bring in this case, and which documents, videos, and reports to show you. With all of that under their control, they still must prove, as alleged in their indictment, each and every element of each offense beyond a reasonable doubt. You do not convict because you have doubts about what the defense proved. You do not weigh the state and the defense like two sides of a scale and pick whichever you like better. That is not the standard. You only convict if, after considering the evidence in the law, you are convinced beyond a reasonable doubt that the state has proven every element it chose to allege. So when you go back to the jury room, the question on each count is not, can we imagine a way the state's theory might be true? The question is, has the state proven the charge and each element of it? And to the point that I have no reasonable doubt about the defendant's guilt. If, after honest, careful consideration, your answer on any count is no, or I'm not sure, then the law gives you only one verdict on that count, not guilty. That is not a favor to these defendants. That is how you uphold the presumption of innocence and the burden of proof that protect every person who comes into a courtroom in this state, including everybody in this community. If the state has not carried its burden beyond a reasonable doubt, your oath requires you to say so with your verdict. And in that circumstance, the only verdict is not guilty. So, I'd now like to take you through the charges. These essential elements that the state must prove. We'll start with count 1, felony murder. Under Georgia law, felony murder does not simply mean someone died. For felony murder, the state must prove beyond a reasonable doubt that these defendants caused the death of Mr. Martin by committing a specific felony which the state has chosen and alleged in the indictment. In this case, the state has alleged aggravated assault with a deadly weapon as that felony. That is their choice. That is what they have alleged, and that is what they must prove. So the state's burden on this count has two major pieces. They must prove beyond a reasonable doubt that there was an aggravated assault with a deadly weapon, as they have alleged. They must prove that this felony caused Mr. Martin's death. And if they fail, if you still have a reasonable doubt in your mind as to an essential element on either of those, count one falls. Now, what does that mean in this case? First, aggravated assault with a deadly weapon. Here, the alleged deadly weapon is a taser. So the state has to prove beyond a reasonable doubt that there was an assault on Mr. Martin, and that in the way that it was used in this incident, the taser was in fact a deadly weapon. If you look at the evidence and conclude that what you saw was officers acting under their authority to effect a lawful arrest, using a level of force they believed was appropriate under the circumstances, then you can reasonably doubt that there was any assault at all. If you believe these officers were justified in their actions, there's reasonable doubt on the very existence of an aggravated assault. And remember, the burden is not on the defense to prove beyond a reasonable doubt that the officer's conduct met some threshold. It is the state's burden to prove that the conduct was unlawful. And even if you set that aside and ask, was this taser a deadly weapon in this case? The state still has a problem. It is not enough for the state to say, well, a taser can be dangerous, or in some other case, somewhere, a taser might have been deadly. The question for you is much narrower and more precise. Does a taser, in the manner in which it was used in this incident, constitute a deadly weapon? If you have any reasonable doubt about that, if you have any reasonable doubt about what was not said, if you have any reasonable doubt about what was presented, and I urge you to search the testimony of these experts. If there is any reasonable doubt, the state has not carried its burden on the deadly weapon element of aggravated assault, and you must acquit as to that charge. And remember, the judge will instruct you that there must be some causal connection between the felony and the death. The felony alleged here is aggravated assault with a deadly weapon. If you're not convinced beyond a reasonable doubt that this taser as used here was a deadly weapon, or that there was an unlawful assault, then the state has not proved the underlying felony, and there is no proven aggravated assault with a deadly weapon, and there can be no felony murder based on aggravated assault with a deadly weapon. Now let's talk briefly about cause of death, because that matters too. You heard from Dr. Lehman. You heard him say that Mr. Martin's death was caused by the stress of his own resistance during police restraint. You heard the defense expert, Dr. Graham, agree with that central point. You heard Dr. Vilk say essentially the same thing, that the stress of Mr. Martin's resistance, combined with underlying health risks that were invisible to these officers, ultimately led to his collapse. I don't need to retell everything that you heard from Drs. Vilk and Graham. You know what they said, and you know what they stood by against the state's cross-examination. Dr. Graham even gave you important context. There can be restraint without resistance. There can be restraint without resistance. Someone can be restrained and not resist. Police brought the restraint, but it was Mr. Martin who brought the resistance. His resistance was the engine that drove the stress response that led to his collapse. None of these experts, not one, told you that the taser as used in this case was the sole cause of Mr. Martin's death. Dr. Lehman didn't even write the word taser in his autopsy report. He referred to cardiac arrhythmia during police restraint. Dr. Graham told you restraint alone doesn't kill. There must be resistance. But neither of them concluded that the application of the taser was the ultimate cause of Mr. Martin's death. What did you hear instead? You heard Mr. Lipscomb ask questions, lots of questions, suggesting, insinuating, inviting you to think that maybe the taser was deadly here. But questions are not evidence. What the lawyers ask is not evidence. Only what comes from the witness stand and the exhibits counts as evidence. And on the evidence, the only experts qualified in tasers, Dr. Kroll and Dr. Vilk, told you that in their professional opinion, the taser as used in this case would not have been capable of killing Mr. Martin. Mr. Martin was not electrocuted. These experts, one, a PhD with expertise in bioelectricity and electrophysiology, the other a physician in emergency medicine with extensive research on tasers, agreed on this point. The taser did not cause his death. Now, Mr. Lipscomb wants you to believe that an expert who is compensated for their work, compensated for their contributions, must not be believable, or must not be believed, or must be biased. That's fine. That's why these men came and talked to you about science. That's why these men walked you through a demonstration of their analysis, not a 7th grade science fair project, or however Mr. Lipscomb put it. The point is not for them to tell you what to think. The point is to give you the information so that you will know how to think about this situation and this taser used in this case. If you have any doubts about their qualifications, search their CVs. Find where they're not qualified, to give their opinion, where they lack the necessary information. An example of that might be the one expert, attempted expert, that the state put on the stand. They wanted to qualify Carmichael as an expert in tasers. They wanted you to take the opinion of their witness. So we explored that. Do you know anything about the effects of electricity on the body? No. Do you know anything about the way the taser functions to regulate voltage or amperage? No. Do you even know how to interpret the documents, the data that these devices put out to allow you to determine what was going on? No. That's who the state wanted you to hear from. And yet they now want to tell you that the experts who are qualified eminently, highly respected in their fields, highly educated, those are the crackpots. When you put it all together, the law, the elements of felony murder, the need for a real aggravated assault with a deadly weapon, aggravated assault with a deadly weapon, and the need for a causal connection between that felony and the death, and the state's burden to prove the essential element beyond a reasonable doubt, you're left with this. If you have any reasonable doubt about whether these officers committed the aggravated assault alleged, if you have any reasonable doubt as to whether a taser, in the manner in which it was used in this case, was a deadly weapon, if you have any reasonable doubt that the alleged felony caused Mr. Martin's death, then the state has not carried its burden on count 1. And when the state does not carry its burden beyond a reasonable doubt, your duty under the law is clear. You must say not guilty on felony murder. So let me turn now to count 3, aggravated assault with a deadly weapon. Obviously, you've already heard a lot about this. For this count, the judge will instruct you that the state must prove beyond a reasonable doubt that the defendant attempted to cause a violent injury to Mr. Martin with a deadly weapon. The deadly weapon alleged, again, is the taser. Whether something is a deadly weapon depends on several factors the judge will instruct you on. The nature and extent of any injury inflicted, the character and capabilities of the object, and the manner in which it was used in this particular case. You promised to decide this case based on the evidence. So let's look at what evidence the state actually gave you on these points. First, the character and capabilities of the tasers used. The state didn't qualify a single expert to explain the capabilities or characteristics of the taser. Not one. No engineer, no one to opine about the physiological effects, how the device works. In fact, in their opening, the state told you that there are 15 trigger pulls, and we don't even know if the evidence will prove that those 15 trigger pulls produced any effect. Meaning, when they started their case, they didn't even know if the evidence would show it. When they started their case, there wasn't a plan to have an expert teach you what you need to know to make the kind of determination that Dr. Kroll, through his demonstration, showed you. They told you that in the state's experts, Dr. Kroll and Dr. Vilk, the defense experts, Dr. Kroll and Dr. Vilk, told you that in their expert opinions, as used in this case, these tasers were not capable of killing Mr. Martin. They told you that Mr. Martin was not electrocuted. Dr. Kroll analyzed the actual downloads and told you there was an aggregate of about 9 seconds of good probe connection. 9 seconds of the kind of connection that can produce muscle lockup. You heard that talked about over and over. Not 20, 30 seconds, not some prolonged unknown duration, about 9 seconds. That's less than the 15 seconds you would see from 3 full 5-second cycles, the so-called baseball rule that you've heard about. They told you the probe spread was relatively narrow, not the wide spread that produces full neuromuscular incapacitation that some witnesses had experienced in training. They explained that the narrow spread means a more limited physiological effect. They testified, as did every other medical expert with knowledge of the facts of this case, that there were no prongs near or around the heart. So on the character and capabilities of these tasers, the only expert testimony in this case cuts one way. The tasers, as used here, were not deadly weapons. The state tried to distract you from that by attacking these experts personally. You heard more of it this morning. You heard a lot of it. Mr. Lipscomb asked them about their financial compensation, about that, whether they had memorized every word of a warning label. He asked many questions. But again, the questions are not evidence. The answers are. And the answers from these experts did not change. They did not waver. They remained firm that the tasers as used in this case were not capable of causing Mr. Martin's death. Further, they explained to you why they were not capable. They explained to you the electrical potential. They explained to you what would be needed to have some sort of interference with the heart. They explained to you the way these function physiologically is to lock up muscles to make it easier and safer to take somebody into custody. They explained that to you. The state did not put on a single witness to explain any of that. Now look at the manner in which the tasers were used. You saw the videos, you heard the testimony, you heard about Mr. Martin's resistance, his struggling, his pulling away, and the officer's attempts to gain control. You didn't hear any witness, expert or otherwise, say that the manner in which the tasers were used here was calculated to kill, or that it was likely to cause death or serious bodily injury in these circumstances. You heard instead that Mr. Martin's resistance created this sustained stress that, coupled with his hidden medical risks, led to his collapse. This is what Dr. Lehman, Dr. Graham, Dr. Vilk all told you in one form or another. None of them said the taser caused this death. None of them said the taser used here was deadly. So when you apply the law, looking at the nature and extent of the injury, the character and capabilities of the taser, and the way they were used, ask yourself this simple question. Has the state proven beyond a reasonable doubt, through the evidence, that a taser, as used in this particular case, was a deadly weapon? Not, could a taser somewhere sometime be deadly? Not, did a warning label mention a risk in some hypothetical situation? The question is whether the state has proven that these tasers used this way in this encounter were deadly weapons. On this record, they have not. If after considering the testimony of the experts, you have any reasonable doubt about whether these tasers as used here constituted a deadly weapon, the law leaves you only one option on count 3. You must acquit. And if there is no aggravated assault with a deadly weapon, there's nothing for count 1's felony murder charge to rest on. You heard a lot about tasers in this trial, but almost all of what you heard came from experts who told you tasers in this case were not deadly, did not cause Mr. Martin's death. This is not a side issue. This is the essence of reasonable doubt on these counts. Now, on to counts 2 and 4. Count 2 is involuntary manslaughter based on reckless conduct. Much of what we covered as to felony murder based on aggravated assault will apply in a similar way to this analysis. As with felony murder based on aggravated assault, if you have any reasonable doubt as to whether a defendant committed the offense of reckless conduct, you must acquit as to involuntary manslaughter based on reckless conduct. Because without reckless conduct, you cannot have involuntary manslaughter. For involuntary manslaughter based on reckless conduct, the state must prove beyond a reasonable doubt that the defendant caused the death of Mr. Martin without intending to do so by committing specifically the offense of reckless conduct. Just as in count 1, if the state cannot carry their burden as to reckless conduct, there can be no involuntary manslaughter. Count 4, reckless conduct. Ladies and gentlemen, I want to walk you through count 4, reckless conduct, because the words in that law matter. The state doesn't get to just say reckless and have you fill in the rest. They have to prove each part of this offense beyond a reasonable doubt, or else you must acquit. For reckless conduct, the court will tell you that the state must prove that the defendant caused bodily harm to Mr. Martin by consciously disregarding a substantial and unjustifiable risk that the defendant's act would cause harm to Mr. Martin, and that this conscious disregard was a gross deviation from the standard of care a reasonable person would use in that situation. If the state fails to carry its burden, if you have any reasonable doubt as to any one of those parts, your verdict on count 4 must be not guilty. First, caused bodily harm. First, they have to prove that the defendant caused bodily harm to Mr. Martin. Not just that harm happened, not just that Mr. Martin was hurt. They have to tie it with evidence to what a defendant did and show that his act actually caused bodily harm. Recall that the medical examiner did not find any bruises, scrapes, lacerations, no evidence of compression to the chest. There was no evidence that Mr. Martin was hit, kicked, held around the neck, or that any weight was put on top of him. Mr. Scott described the scene clearly. Mr. Scott described officers around Mr. Martin, standing to his side, standing above him, kneeling on the ground next to him and around him, trying to get his one handcuffed arm out from underneath his body. The state also made comments about the officers' uniforms not being dirty, not being disheveled. And I would submit that the conduct of the officers in kneeling next to Mr. Martin and attempting in as controlled a way as possible to effectuate an arrest in a way that was not designed to beat, injure, maim, but to complete the arrest is demonstrated by the fact that they are not disheveled, that they did not engage in some prolonged wrestling match on the ground. If after you've heard all the evidence, you are not firmly convinced that a defendant's actions are what caused bodily harm to Mr. Martin, the state has not met the first requirement of reckless conduct. Consciously disregarding. Next, it's not enough that someone was careless or made a mistake in judgment. Instead, consciously disregarding a risk means the person recognizes there's a risk, is aware of it in the moment, and then chose to ignore it anyway. If the most you can say is, maybe he should have thought about that, or looking back, he could have done it differently, that is not conscious disregard, that is hindsight. There's been a lot of hindsight in this case. There's been a lot of analysis, second by second, asking what happened. That is not what happens in the field. Consider what these officers did not know, and don't be misguided into thinking that these officers should have considered any knowledge or information that they did not have. Reckless conduct requires proof beyond a reasonable doubt that the defendant actually appreciated the risk at the time and went ahead anyway. Substantial and unjustifiable risk. The risk itself has to be both substantial and unjustifiable. Substantial means not a small risk, not a remote or trivial possibility. It has to be a serious risk of harm. Unjustifiable means that in the situation the defendant was facing, there was no reasonable justification for taking that risk in that way. In everyday terms, this is not about tiny chances or split-second decisions that carry some danger because real life is messy. It's about big, serious risk that no reasonable person would accept in that situation. If the risk is debatable, if it's low, if it's tied up with competing dangers or duties, then the state has not proven substantial and unjustifiable risk beyond a reasonable doubt. 4, that the defendant's act would cause harm. The law requires that the risk the defendant allegedly ignored was a risk that his act would cause harm to Mr. Martin. Not might conceivably cause some harm in some hypothetical case. It has to be a risk that in these actual circumstances, his act would cause harm to Mr. Martin. If the evidence leaves you unsure, if you're left guessing, the state has not carried this element beyond a reasonable doubt. Gross deviation from the standard of care. Finally, and this is critical, the law does not criminalize ordinary negligence. The court will tell you that the defendant's conscious disregard must amount to a gross deviation from the standard of care that a reasonable person would use in the same situation. Gross deviation means something far beyond a simple mistake, bad judgment, or ordinary carelessness. It means conduct that is so far outside of what a reasonable person would do that we would call it criminal. If you think maybe he could have done better, or maybe that was careless, that is not a gross deviation. The state has to prove that what he did was outside the bounds of what an ordinary reasonable person in his position would have done. Bringing it together, when you go back to the jury room on count 4, these are your questions. Has the state proven beyond a reasonable doubt that this defendant's actions actually caused bodily harm to Mr. Martin? Has the state proven that he consciously, actually, knowingly disregarded a substantial and unjustifiable risk that his act would cause harm? And has the state proven that his conduct was not just careless, but a gross deviation from what a reasonable person would have done? If any of those questions, if to any of those questions your honest answer is no or I'm not sure, then that's a reasonable doubt. And with a reasonable doubt, your sworn duty on count 4 is to say not guilty. Now, some other issues that we touched on. Is walking in the roadway actually a crime? Yes. And the judge will instruct you. This is the statute. This is the statute that the state felt important enough to write down so that we would know what it says. Where a sidewalk is not provided, but a shoulder is available, any pedestrian standing or striding along and upon a highway shall stand or stride only on the shoulder as far as practical from the edge of the roadway. And you'll find out that highway and roadway have specific definitions. Shall stand or stride only. Not maybe, not kind of, not only sometimes. Are police actually allowed to arrest someone for walking in the roadway? Yes. This also has been talked about, and I don't believe there was any conflict in the evidence that when an officer observes the commission of a crime in his presence, there is the authority to arrest. That includes knowledge or reasonably trustworthy information, like the information shared amongst the 3 officers on that day. This is true either when the officer is relying on a good faith belief that someone is walking in the room. The officer can still legally arrest. So the officer is allowed to arrest. What if the officer doesn't write it down later, that walking in the roadway was his reason? Does that now make a legal arrest into an illegal arrest? No. The arrest is still legal. Based on the actual facts, there's no requirement that says write it down or it doesn't exist, or if you didn't say it, it doesn't count. The question that matters is, do the facts exist to support the decision to detain and or arrest? The last thing I want to leave you with is, again, sort of pertaining to burden of proof. You know, in a typical case, and I'm not sure that there really is one, the state makes an accusation, writes it down in an indictment, puts on evidence, you know, there's a trial. They do that because they have the burden of proof. The defense does not have to put on any evidence at all, and they are still given the presumption of innocence. In this case, however, the defendants put on a tremendous amount of evidence, brought you experts who are experts in the fields that matter to your decision, that matter to your analysis in this case. What I don't want you to do is mistake the defense's efforts to supply evidence to prove, if you will, their position. I don't want you to mistake that with the defense having a burden to prove what they put on. In fact, the reason we put it on, it goes directly to the heart of the state's burden. There is reasonable doubt. Reasonable doubt. I mentioned this with the taser. A central part of this indictment, perhaps the key element of this indictment, is that the taser is a deadly weapon. The state wrote it down. They brought 0 experts to tell you about how that could be. None. What did they do? They took the defense's experts and asked them, what if this? What if that? What if it did this? What if it was the facts of a warning label? The state is demanding doubt. The state is demanding that in this case, that you have doubt about something that the defendants are saying. The defendants have no burden in this case. The burden is on the state to prove the elements of the crimes that they've alleged. What they have brought you is doubt. They brought doubt into the case. And that's what they've left you. I want you to think about that. I appreciate your time. I appreciate your attention. Thank you.
Don't need a break.
Just,
You need a break?
just a moment, just a minute, let me ask.
Sure, absolutely.
Ladies and gentlemen, you've been here for a while now, obviously, and let's just take a 10-minute break. Do that, and then come back and we'll proceed with the remainder of the arguments. You may be seated. The defendants may proceed.
Thank you, Your Honor. May it please the court, opposing counsel for the state of Georgia, co-counsel's permission to move about the courtroom.
Certainly.
Good afternoon or good morning still, ladies and gentlemen. I think I would be remiss if I didn't immediately acknowledge and express sympathy to the family of Mr. Uri Martin, the friends of Mr. Uri Martin. Anytime someone dies, it's a tragedy. It's a tragedy to their sister, it's a tragedy to their cousins, it's a tragedy to their mothers and fathers, if they're still alive. It's a tragedy to their friends. And we can be sympathetic towards that, and we are. Heartfelt sympathy. Please don't confuse my zealous representation of Mr. Howell as well as Mr. Copeland, Mr. Scott, with a lack of sympathy for the loss that they suffered. However, that sympathy, that loss, is not the fault of Michael Howell. It's not the fault of Henry Lee Copeland. It's not the fault of Deputy Rhett Scott. I'm not going to sit here and blame Mr. Martin for his own death. That's unfair. It's unfair based on his condition, based on who knows what was going on through his mind at that time. Mental health is an issue in our society. Mental health, a person that's involved in a mental health crisis, presents problems that are difficult for the average person to identify, to diagnose, and to deal with. So please don't take anything that I say or evidence that we presented as some type of blame on Mr. Martin. He didn't get schizophrenia through any fault of his own. I would not blame any previous alcohol dependency or cocaine abuse solely on Mr. Martin. As the testimony was, there's, sometimes that's the way that people try to cope and deal with that type of issue. I would not blame the fact that he wasn't taking any psychotropic medications or medications for schizophrenia at the time on Mr. Martin, because that's common in our society, that people are non-compliant for one reason or other, especially when it has to do with mental health. The second thing I'd like to do to you, is to thank you each for being here. This has been an abnormally long trial in the grand scheme of things, but it's for a very serious case. You have a difficult job, and you have each given to this court, given to the state of Georgia, as well as to these officers, what I have felt is your undivided attention. What has been taken away from you is your time from your families, your time from your work, your time from anything else that you would like to do. But you've sat here and you've listened to the testimony and evidence. You've taken notes on things that you thought were important, questions that you think that you wanted answered. And I thank you for that. I want you to continue to listen carefully as I describe to you what the evidence has absolutely shown in this case. has not shown in this case. Where there are conflicts in the evidence and how you can resolve those cases. I always like to remind jurors that this was a selection process for you. Hundreds of jurors. And between the state of Georgia and counsel for Michael Howell, Lee Copeland, and Rhett Scott, we specifically chose you as jurors. We specifically chose you for your impartiality. We chose you because you told us that you had no preconceived notions or opinions on this particular issue. Some of you had no knowledge of the issue whatsoever. We chose you because you're reasonable people. Mr. Lipscomb, Mr. Schaefer have already gone over several laws with you, one of those being reasonable doubt. In my mind, based on the selection process that we went through to get you, the extensive questionnaire that you filled out, the question that you asked, that we asked during voir dire, I would say that you're reasonable people. And I would say that in thinking about that, in terms of reasonable doubt, if you have any doubt about this case, about the guilt of these defendants, then that would be a reasonable doubt. Y'all are reasonable people. The state of Georgia has brought these charges, and they brought other charges, which you're aware of, that have already been null prost or dismissed. The state carries the enormous burden of proving beyond a reasonable doubt each of these crimes. As previous counsels have told you, the defendants have no burden at all. It is my belief that based on the evidence and the testimony that's been provided, not only has the state not proven guilt of any charge beyond a reasonable doubt of these individuals, that we have proven beyond a reasonable doubt that these gentlemen are innocent of any criminal charges. That these gentlemen were attempting to effect a lawful detention, attempting to effect a lawful arrest. This case is not about poor Mr. Uri Martin getting tased because he wanted water. This case is not about Mr. Martin being tased and attacked by officers because he was walking on the roadway. It's the totality of the circumstances that we have to look at. And we have to look at that through the eyes of the law. Number one, we've all agreed that police officers have a right to detain somebody if they suspect they have committed a crime. They have a right to arrest somebody if they have probable cause that they've committed a crime. We all agreed on this jury panel that it didn't matter what the offense was. We've asked some of the witnesses that as well. It doesn't matter whether it was someone barely rolling through a traffic light or a stop sign. Once an infraction occurs, the police officer has the right to stop that person. The person has no right to flee or continue to walk away or to drive their car away. That then just culminates what the totality of the circumstances are. It's kind of a snowball effect, if you can picture it that way in this particular case. The first thing we have to kind of look at, I think, is expectations of the community, expectations of law enforcement, and how people normally react to different situations. We have to look at what these officers knew at the time that they were making their decision, because the court will instruct you, as I talked about previously, that this is not a hindsight is 20/20 and what the police should have done, what they could have done better. This is when a person has, or a police officer has, the lawful duty, can lawfully make an arrest or a detention. This is about looking at what the officer knew at the time, not with the benefit of hindsight, not with the benefit of being a Monday morning quarterback who's critiquing everything that happened in that situation. It's about what they knew at the time, what their reasonable beliefs were at the time, what they did not know at the time. Obviously, it is undisputed that neither of these three officers had ever met Uri Martin, knew Mr. Martin. It is undisputed that none of them knew that he had schizophrenia. It is undisputed that none of them knew that Mr. Martin had been walking in the July heat in the 90s from Milledgeville to Sandersville. It is undisputed that none of these officers knew or could have known that Mr. Martin had an enlarged heart, that Mr. Martin had hypertension, that Mr. Martin had scars on his heart tissue, that Mr. Martin had an elevated hyperthermic temperature. None of that was known. The call, which you have heard, goes out from a person who has concern. Cyrus Harris calls 911 in Washington County and expresses concern to the dispatcher. I can't tell you why Mr. Cyrus Harris refused to give that guy water. I can't do it. I can't tell if it's because he was alarmed at the guy's presence, how he approached him. But whatever it was about him, he was concerned. He called 911. 911 took that call, and at no time did Mr. Harris reveal that, oh yeah, this gentleman just wanted some water and I sent him on his way, so you should send a deputy to give him water. The only information that Michael Howell knew, that Henry Lee Copeland knew, that Rhett Scott knew, was this was a suspicious person call, and a gentleman with a description had walked into the complainant's yard, Mr. Cyrus Harris. Prior to that, there was other concern. Mr. David Blizzard, the mail carrier here, indicated that he had seen Mr. Martin on many occasions that day, indicated that when he talked to him, he had some abnormal type speech issue. It was hard to understand him, but he gave him water, thankfully. He expressed concern that he almost thought about calling the police, but he didn't. He expressed concern about the gentleman who he had never seen, despite being on that route for 20 plus years, so much to the extent of, based on his mannerisms and how he looked, that he let his daughter know about it, just so that she would be aware. You know, if you hear the dogs barking, you know, I just encountered this man. The state of Georgia showed you a picture of Mr. Martin when he graduated high school. That was not the person that David Blizzard encountered. That was not the person that Cyrus Harris encountered. that was not the person that these deputies eventually encountered. I would submit to you that the person that David Blizzard encountered, the mannerisms and how he acted and reacted to Mr. Blizzard, was not the same person that these law enforcement officers encountered after walking repeated more miles in the July summer heat under those conditions in some type of what I would say was a mental health and possibly a medical crisis, because he reacted differently. He reacted differently to the police than he did Mr. Blizzard. He reacted differently and in an unexpected way. The second thing we know about where there was definite concern for Mr. Martin was a telephone call placed by his sister, Helen Gilbert, sometime after law enforcement had already encountered Mr. Martin. She indicated in that telephone call that, well, let's just play it for the jury members.
Central Subject of a detailed road just below Mount Sinai Church.
Washington County 911, what's your emergency?
Hi, I was calling because I had got a call from one of my family member, and they was telling me that Yuri Martin, he was headed toward D-Step, and he's out there in all of that weather, and he's a mental patient. He live up there in Millersville, but he headed towards Sandersville. And he's, coming on D-Step Road, headed, towards Sandersville. I don't know whether he's coming straight or whether he, turn off on one of those side roads. But he is a mental patient, and his name is Yuri Martin.
What's his name?
Yuri Martin.
Euless Martin?
It's E-U-R-I-A, Martin.
Okay.
Yeah, I would have went myself, but at this time, just emotionless,
And he was
I
walking?
just ain't in no condition to go out there and get it myself.
And he was walking?
He's walking. He headed towards Sandersville.
Where was he last at?
In that telephone call, which we know was placed in the evening when it was already dark, after these deputies had already encountered Mr. Martin, Ms. Gilbert indicates that family members of her, family members of Mr. Martin, saw Mr. Martin walking on Deep Step Road. They called her out of concern. There's no evidence that those individuals stopped for their own family member, tried to assist him, just that they had seen him walking from Milledgeville towards Sandersville on Deep Step Road. Ms. Gilbert expressed concern because it was now getting late and there was a storm coming in, the weather. But she had not acted on that information initially and gone out to seek Mr. Martin. But she was calling law enforcement, the Washington County 911 Center, with her concerns and asking for help. Had this situation been a response to Ms. Gilbert's telephone call when she was asking for help, and Mr. Martin, everything else being equal, had acted the same. It doesn't change the fact that these deputies had no knowledge about any of this information. Let's talk about some of the information that they did have. If you don't mind.
No, please, help yourself. I can
This has been, is this a copy?
That's my notes. I don't know if you want to show it to them, but you can.
Okay, I don't know where it, this is one of the exhibits that's been provided. Mr. Lipscomb asked the experts about it. I think one of the responses was that this was a warning label written by lawyers. This wasn't shown to Deputy Howell. It wasn't shown to Rhett Scott. There's absolutely no evidence that you've seen in this case or heard from this witness stand that any of those deputies were ever provided this, that any of the deputies were ever trained on this. And this is the sole lawyer's warning that the state would like you to rely on to say that, yeah, a taser is a deadly weapon. We see warning things throughout our life on everyday products, warning of things that we all know that lawyers have put on there for some reason because somebody did something inappropriate. Let's talk about the training that they did have. Number one, let's talk about the policies of the Washington County Sheriff's Office that we've talked about, and that were all indisputed, no dispute whatsoever. Non-deadly force is a quantity of force which is neither likely nor intended to cause great bodily harm. Deadly force is the degree of force that could cause death or great bodily harm. You go to the next slide. When can non-deadly force be used? In the performance of his or her duty, when necessary to preserve the peace, prevent the commission of an offense, preventing or interrupting a crime, when making lawful arrests and searches, overcoming resistance to such arrests and searches, preventing escape, when in self-defense or defense of another against unlawful violence to that particular person. Next slide. The use of non-deadly force. The following non-deadly weapons and methods are authorized by the Washington County Sheriff's Office as non-deadly force. You will see that it includes electrical weapons. The evidence is undisputed that the taser device that were employed and used are electrical weapons that were issued and in compliance with this. Next slide, please. Talked about with Chief McGraw this very same thing, the use of force continuum, the options that are available to officers, command presence, them just being there in their uniform and in their patrol cars, verbal commands, telling an individual to do something. These are all still levels of force that are non-deadly. I'm directing a citizen to do something. I'm giving a citizen a lawful order to stop, to get out of the roadway, to put your hands behind your back, to roll over when trying to effectuate an arrest. After that, soft hand control, like trying to guide somebody out of the roadway, placing your arm on somebody, trying to move them. Next, we see chemical agents, which we know were not applicable in this case because none of the deputies had them. And the next use of force that it is undisputed from this witness stand that is to be used or considered is the use of force that is most likely to gain compliance from a non-compliant subject without the danger of risk to the subject or to the officer, and that is the electrical taser. After that, we go to hard hand control, which is punching and kicking a person, and then impact weapons like aspartans and things like that. All of these things, non-deadly force. And then it goes to deadly force, again, force that is likely to cause great bodily harm or injury. Now further, we'll go on to what they were most recently trained on. I believe that the testimony was that it was in March. Well, in fact, I can actually pull it right up. March the 15th, 2017. I want you to take this when you get back to the jury and let's take a look. Not only are the names of these deputies on here for the use of force training that retired GBI agent John Durden provided them, but Thomas Smith, the current sheriff at the time, he signed this and was there. Michael J. Cochran, I'm assuming that's the sheriff now, Joel Cochran. Chief McGraw took this training. Michael Howell. Numerous other law enforcement officers, all trained by GBI agent Durden. And what did Agent Durden tell him in that training? This is what the state provided us as what the training was. I apologize for the enlarged slides, but this is what I've got to work with. If you cannot read it, you'll have these because they were tendered as exhibits. You can make your own decision about what they actually say. Agent Durden taught these officers, as well as the current sheriff and the other individuals that I mentioned, including Chief McGraw, that non-deadly force is force that is not likely to cause death or serious bodily harm. It's used to defend yourself or someone else or a third party from the unlawful use of force. Deadly force is force that is used that is likely to cause death or serious bodily injury. Next slide, please. When may the officers use force? To compel compliance with lawful commands, overcome physical resistance by a subject, prevent escape or restrain a subject for purposes of an arrest based on probable cause, to detain or restrain a subject during an investigatory stop based on articulable reasonable suspicion. These things that are in these slides will be in the law that Judge Flanders tells you. These things are law. That's what they're being taught. They can use force to preempt a risk of injury to the officers or others, or achieve other legitimate law enforcement purposes where mere presence and verbal commands fail. Next slide. They're also taught, and they are certainly familiar, that use of force incidents are stressful, and they're dangerous for the involved officers. They're dangerous for everybody involved. Next slide. Pre-attack indicators that they were taught include clenching one's fist, glancing at an officer's weapon, target glance, eye contact, a bladed or fighting stance, flanking, abnormal breathing, posturing, nervous movements, body grooming. Next slide. Benefits of proactive use of force. That it's generally less force used when it's proactive. There's less injury to the suspect, less injury to the officer. Quick decision now equals less force later. These things are absolutely undisputed. That's what was talked about. That's what they knew in advance. What did Michael Howell respond to? A suspicious person. Not a crime in itself. Not something that would allow Michael to get out and put handcuffs on an individual. What culminates as he responds to that escalates the situation, escalates the type of encounter. Mr. Howell, in responding, tells the dispatchers that he is out with that subject, who matches that description, on Deep Step Road. He tells you right here, it's undisputed that Michael Howell told you that he saw him walking on or in the roadway. That is a violation of Georgia law, however minor. Just like running the stop sign, barely rolling through the stop sign. Michael Howell also told you that that's not something that, he's not going to jump out and arrest somebody for that, but you have a suspicious person call, a person matching that description, and now you've seen that they're in violation of a small law, gives you the right to stop and detain them and talk to them. Mr. Howell told you that if Mr. Martin would have acted like he expected a citizen of Washington County or a citizen traveling through Washington County would have reacted, that if he would have told him that he just needed some water and he was walking from Milledgeville to Sandersville, that he would have tried to get him water, that he would have taken him, put him in his patrol car because it was too hot for him to be out on such a long walk in the July summer heat. The response that Michael Howell got was, "Who are you?" which was unexpected. Michael told you that it raised concern with him, the way he looked, the way his mannerisms were, the way that he just looked at him. And Michael Howell is a large individual. And he told you that something was wrong. And he called for backup because he wasn't going to get out of the vehicle and interact with this individual on his own. Didn't tell him to stop. Mr. Martin didn't give him an opportunity to tell him to stop. "Who are you?" And he walked away. So Michael Howell called for backup, explained that this individual didn't want to talk to him, and other deputies responded. He dutifully turned around, followed behind him with his rear lights activated to alert traffic, eventually turning on his camera, which the only thing we would have seen had he turned on his camera earlier was exactly what he told you, is exactly what we saw in the video. Mr. Martin walking in and out of the roadway, sometimes on the fog line, sometimes in the roadway, sometimes on the shoulder of the roadway. I'm not going to play you all Michael Howell's video. If y'all want to see that, let the judge know, let the bailiff know that you'd like to see it again. There are ample exhibits that have already been tendered into evidence that show Mr. Martin walking in the roadway to the right of the fog line. Ample. How also do we know that Mr. Martin was walking in the roadway is, you can skip a couple ahead to the incident report. He wrote an incident report in which he specifically indicated, and Chief McGraw approved after direction on how to write this report from someone in the department, that he observed the black male on the right side of the road, walking toward traffic that was headed towards Milledgeville. Sergeant McGraw's report later also indicated that Mr. Martin continued to walk down the road, and that Deputy Howell had, in fact, saw him walking on the road. Once Sergeant Copeland arrives, and somewhat prior observations. They see that Mr. Martin is walking and holding a Coke can in his left hand. They pull up, they create an area that is blocking traffic from the rear, blocking traffic from behind, and attempt to make contact again with Mr. Martin, who has been walking for some time. Walking with, knowing that there is a deputy walking or driving behind him as he turns around repeatedly on the video. And immediately, Officer Copeland starts giving him commands. Come on, get out of the roadway. We just want to talk to you. Come on, get out of the roadway. We just want to talk to you. And unfortunately, we don't have a 360-degree patrol car camera footage of what goes on. Unfortunately, we don't have body cameras because they weren't issued to the officers by the sheriff's office. All we have is the patrol car videos. And then the evidence and testimony, which is undisputed, is that once they walk off camera as they're giving him these commands to get out of the roadway, to come over here, to stop, to come talk to them, that Mr. Martin throws down that Coke can, just like Michael Howe showed you, and gets in a defensive or offensive stance, clenching his fist. That right there is 2 additional criminal offenses that have elevated this encounter, if not 3. Refusing to obey a lawful command of a law enforcement officer is a misdemeanor obstruction of a law enforcement officer. They had a right to stop him. They had a right to detain him. When they told him to stop, he didn't. Throwing a Coke can down on the ground is littering. Getting in an offensive stance, offering or threatening to do violence to the officers is felony obstruction of a law enforcement officer. It's certainly a felony later on when he actually takes a swing at Sergeant Copeland. It's certainly a felony later on when you watch on video him try to take a swing at Rhett Scott after being tased. That is offering to do violence, attempting to do violence. So it's this culmination of things, not one specific thing. It's a dynamic and fluid situation in which officers have to make split-second decisions, in which officers are reacting to someone in a way that's unexpected, in which officers are reacting in a way or reacting to someone who is concerning them. This is not a situation that officers just allow people to go walk on. Oh, he did these things, but he's so angry at me and threw down this Coke can and put up his fist, I'm just going to go let him walk into the Deep Step community. I'm just going to go let him walk on to Sandersville. The people in the state of Georgia, the citizens in Washington County, would not expect a law enforcement officer to just let a person go at that time. After giving repeated, let's just watch that's probably the best source of listening to how many times Mr. Martin was given verbal commands is the video footage and the audio footage.
Come on over here. Come on over here. Come on over here. Come on. Get out of the road. Get out of the road. Get out of the road. Get out of the road, man. Come on.
With you, man.
Get out of the road. Come on. Come on. Come on.
Leave me alone.
Yeah. Come on. Come on. Come on. Come on. Come on.
Ain't just sit back with me, man.
Well, yes, we just want to talk to you. We just want to talk to you. We just want to talk to you. We just want to talk to you, okay?
What they did us, man?
We just want to talk to you. We, I tell you.
I ain't did shit. I wasn't going to sit me. You don't know.
No, come on now. Get on the ground. Get on the ground. Come on. Come on. Come on. Come on. Come on. You're going to be tased. Come on. Come on. Come on. Get on the ground. Come on. Come on. Come on. Get on the ground. Come on. Come on. Man, come on. Get on the ground.
No. Hey, no. Y'all harassing me. Hell no.
Get down on the ground. Roll over. Roll over. You gonna comply? Put your hands behind your back. Put your hands behind your back, now, damn it. Put your hands behind your back. Put your hands behind your damn back. Put your hands behind your 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 back.
Sergeant Copeland and Deputy Howe didn't have any choice of where Mr. Martin went. They didn't take him and drag him outside of camera view. It's Mr. Martin who resisted, failed to comply with their commands, and went out of camera view when that incident happened. How do we know that that incident happened? Well, second thing is, the next time we see Mr. Martin on video, which is on a cell phone video, he's already going up the hill after this incident has happened. He doesn't have the Coke can with him. That all goes to corroborate what was said, and they were the only ones there. They were the only witnesses. And Michael Howe told you what happened. Therefore, it's undisputed. And his mannerisms of Mr. Martin going forward show you that that's how you expected that individual to have acted, in a way that Michael Howe indicated that he acted. You'll recall from the videos, you'll recall from the audio, that multiple commands were given to Mr. Martin. You'll recall from the video, you'll recall from the testimony here, it's undisputed that not at one time during this entire encounter did Mr. Martin ever comply with any lawful command of law enforcement. Again, I'm not blaming Mr. Martin for that. I'm blaming Mr. Martin's behavior, Mr. Martin's unlawful response, caused by whatever reason, whether it be hatred